Well, thank you, Madam Speaker, and it is indeed a pleasure to be able to stand and speak at third reading on Bill C-77, the amendments to the National Defense Act to change or add some new guidelines and new strengths within the military justice system, something that us as Conservatives have been calling for some time. Conservatives are committed to standing up for the rights of victims and ensuring that victims have a more effective voice in the criminal justice system. And it was our previous Conservative government that enacted the Canadian Victim Bill of Rights. Now, we support enshrining those rights for victims in our military justice system, and that's why in the last Parliament we introduced Bill C-71, and that really is the foundation for which Bill C-77, which we're debating today, is based upon. Now, the Conservative Party will always stand up for the rights of victims, and that's why we're supportive. I've seen Bill C-77 be passed and be enacted. Now, we have to make sure that we restore the rights of victims and that their rights have to be at the heart of our justice system. And that's why the Victims' Bill of Rights is mirrored now into military law once we have Bill C-77 passed through the Senate. And I'm hoping that some of the questions that I still have about the bill and some of the questions that we just heard about self-harm may be addressed when this bill goes through further study and debate over in the other place. We heard through committee, and I'm the vice chair of the Standing Committee on National Defense, we heard from numerous witnesses, and I can tell you that those that are there to support victims were very loud in their support for this legislation that would give victims, one, the enhanced access to information through the appointment of a victim liaison officer, which I think is something that is welcomed by victims in the Canadian Armed Forces. Two, it will enhance the protection for those victims through new safety, security, and privacy provisions so they don't have to be concerned about their self, they don't have to be concerned about their information being used inappropriately through a violation of their own privacy. And it enhances participation through allowing them now to read impact statements at the time of sentencing of the ones that have committed a crime against them. And when possible, it will enhance the restitution through the court-martial process. Will make consideration where possible, provide restitution for the order of the losses to those that were victimized. Now, in the previous government, our Conservative government took significant steps to protect Canadians and stand up for victims of crime. We understand that the highest priority for any government must be to ensure that the safety of its citizens and those that are serving in the Canadian Armed Forces, and that is a responsibility of government. We took that seriously as a Conservative government, and I'm glad to see the ministers taking it seriously within the amendments in Bill C-77. Putting the rights of victims back at the heart of the justice system is important, and it is crucial to ensure fairness, to ensure that our justice system is compassionate, and that it provides a balance both to the rights of the victim and the rights of the convict, or those convicted. So it's about courtesy, compassion, and respect, and that has to be in at every stage of the justice process, whether it's in civilian courts or whether it's in military courts. Now, our previous Conservative government was committed to reversing that trend and keeping our streets and communities safe for Canadians and their families, and we have taken concrete steps to bring those offenders to account for their actions. Now, as all of us on this side of the House, we're proud of our previous government's record, a record that includes the Safe Streets and Communities Act, the reform of not criminally responsible legislation, laws against sexual exploitation, and of course, cyber intimidation and bullying. And we, as Conservatives, believe that it's far too long the criminal justice system was about the rights of criminals, and we believe that the victims have to be placed at the very heart of the justice system. And they deserve and should have the right to information, the right to protection, the right to participation, and where possible, a right to restitution. And that is encompassed in the Canadian Victims' Bill of Rights, which is landmark legislation and is now going to be reflected in the National Defense Act as it applies to our military. Now, really, a lot of people always wonder why we have a dual system, why there is one for civilians and why there is a different system in place for our military members. And I like to use this quote that came from Maurice de Saxe, who used to be the Marshal General of France, and he noted back in 1732 that when he was writing about the science of warfare, that military discipline is the soul of armies. If it is not established with wisdom and maintained with unshakable resolution, you will have no soldiers. Regiments and armies will only be contemptible, armed mobs, more dangerous to their own country than to the enemy. And of course, we have witnessed that in modern times in other countries around the world. And that's why back in 1950, the National Defense Act was established, which established a military justice system. Now, as we know that we already have what I consider the best of the best that serve in the Canadian Armed Forces. And because they are the best of the best, and because they are given the order to use lethal force when necessary in defending Canada, in defending Canadians, in defending those who can't defend themselves around the world, they have to be held to a higher standard. And we have to have a military justice system in place that reflects the law of the land while they're sitting here at home in Canada, but also are still held to that same standard and those same values and under those same principles when they're deployed abroad. Now, as the Minister has already pointed out, that some of the changes that we're doing in the Bill C-77 is about building upon the Code of Service Conduct and Operation Honor in particular. So we want to make sure that we have effective ways to stomp out sexual misconduct, to eliminate harassment within the Canadian Armed Forces, and to make sure that we're dealing with intolerance. So the Gladue decision of the Supreme Court a number of years ago has been put into the decision-making process through the court-martial system, as well as through the summary hearings that have been put in place. And I think that we want to make sure that the ongoing defense of parallel military justice system that has been supported by the Supreme Court of Canada continues on. And as we know, in the Genereux case in 1992, the McKay case, and more recently in the Morarati case of 2015, they have consistently held up that the National Defense Act and the criminal justice system is for the maintenance of discipline, efficiency, and morale of the Canadian Armed Forces. And it stands by Section 11F of the Canadian Charter of Rights and Freedoms. And that charter right is that there is an exemption given to members of the Canadian Armed Forces and to the chain of command to carry out military justice on a parallel track. Now, I do have concern. I raised this at committee, and I raised this when we were at second reading, about the recent court-martial appeals court decision in the Baudry case, which the Judge Advocate General has requested a stand to have that stood away for at this point in time, so that they can take that case to the Supreme Court and have the Supreme Court pass a decision on it. But again, we continue to see some people that don't believe that the military should have their own justice system and that they should be tried under civilian court, except when they are deployed. But overall, we have to continue to have the chain of command, the enforcement of the Queen's rules and orders, and that those regulations are reflective of some of the concerns that were brought up at committee. Now, so we had a number of very powerful witnesses that appeared before committee, Madam Chair, and one of it was, Jean-Guy Perron, who is a retired colonel, who was a JAG officer and also sat as a justice on the court-martial court. And we also had a compelling testimony given by the Bureau du Quebec, and they raised a number of concerns of where there could be potential charter challenges down the road if we don't get this right. Now, one of the things that was very evident is that the change of summary trial to summary hearing may reduce the burden of proof. Right now, the burden of proof, of course, is the same as it is in civil court, which is that it has to be beyond a reasonable doubt. And that has been modified somewhat, and there, of course, the accused could face even more difficulty going forward. So just to quote some of the things that Colonel Jean-Guy Perron said, although a summary infraction is not offense under the National Defense Act and a summary hearing is not a court-martial or a service tribunal, the failure without lawful excuse, the proof of which lies on the person to appear as ordered or to maintain an attendance beyond an officer conducting a summary hearing and as a person charged with having committed a service infraction can lead to an accusation under Section 118.1, failure to appear or to offend, a trial by court-martial, and possibly a criminal conviction. He also then goes on, and this is all in relationship to the summary hearings process. And he says, would minor sanctions be identical or quite similar to minor punishments? Most probably, and if so, the punishments of confinement to ship or barracks and extra work will and drill raise concerns. Commanding officers can confine to ship or barracks for up to 21 days, and this the deprivation of liberty can be very strict and would be similar to conditioning sentencing of imprisonment, such as house arrest. Since that would be considered now imprisonment through a summary hearing without actually having a court-martial process, would the rights of that individual be violated by not having the right to a fair trial because it's been dealt with through the chain of command at a summary hearing? So essentially they're saying house arrest or confinement to barracks is full incarceration as put by the Supreme Court of Canada. You know, burden of proof, and I mentioned that earlier. Bill C-77 keeps the same sentencing objectives and principles as found in a criminal proceeding, most probably the same procedure for summary hearings as presently exists for summary trials in Chapter 108 of the Queen's Regulations and Orders, and increases the punishment power, such as higher fines, of an officer conducting a hearing while reducing the threshold of conviction from beyond a reasonable doubt to a balance of probabilities. Now, we had a lot of debate on the difference between beyond a reasonable doubt and a balance of probabilities. I feel somewhat confident that the JAG officers who were present did a good job of explaining the difference, and that through the regulations of Bill C-77, when we get to enacting those, that will come through the gazetting process, that we should be able to mitigate the charter challenge risk and ensure that the rights of of those that have been charged will be considered appropriately. So, and then also under C-77, Perron goes on to say the accused is liable to be sentenced to a more severe punishment based on a lower threshold of conviction. And the summary hearing under C-77 offers less protections to the accused than what was present in the former bill, the conservative bill C-71, and was actually present in the summary trial process. So I stress to the minister now that knowing that we heard a very similar concern raised by the Barreau du Quebec, that along with Mr. Perron, that we need to incorporate those concerns in the regulation process. We had assurances at committee that that would be done. We brought forward amendments that weren't accepted at that stage on how we dealt with it, but I was glad to see that at least one of our amendments that we did bring forward, which changed it clarifies the rank structure on who can do a summary hearing and who actually would actually review which officers or which NCOs or other enlisted members. The one thing, as we've already been discussing, of course, is that we never did get to fully debate Section 98C, which is the self-harm. It was ruled out of order by the chair. But I do want to thank the member from Esquimalt, Saanich Suk, for bringing that forward. We had Sheila Fines at committee and her family, and they, of course, lost their son, Corporal Stuart Langridge, to suicide in 2008. He served in Bosnia, served in Afghanistan, and they feel very passionately that Section 98C of the National Defense Act, which deals with self-harm, that it does add to the stigmatization, that those that want to hurt themselves won't come forward for help because they could be charged under the National Defense Act, and at the very least be put in front of a summary hearing or could get full court-martial. And we were assured in all the witnesses that this section of the National Defense Act is rarely ever used. And it also, Madam Speaker, really does, for those that are concerned about those that malign themselves, those that actually literally go out and shoot themselves in the foot so they don't have to be deployed, or that they go out there and, and purposely go and sprain their ankles so they don't have to go on exercise and carry their 80-pound rucksack and go marching for 40 miles over the next day. Those that try to avoid service, avoid exercises, don't want to go into theater, that there is plenty of other avenues under the National Defense Act to hold those people to account and bring them to justice for not following orders. But when it comes down to the mental health of our servicemen and women, those who are suffering with PTSD, those who are dealing with anxiety, and those that have been in theater and have witnessed some horrific abuses and atrocities and violations against humanity, those individuals need help. And the last thing we want to be doing is stigmatizing it and sending the message that they will be charged under Section 98C of the National Defense Act for self-harm. So I again hope, Madam Speaker, that we'll see the Minister take this forward and consider it and find a way to bring it quickly back to the House in a different bill if that's possible. I'm sure that you can get unanimous consent at all three stages to delete that section of the Act. Since it was found to be outside of the scope of Bill C-77, I would suggest that we find a different avenue to do it. And that we do it in as quickly as possible, as compassionately as possible, and one that will more than help those that struggle with the thought of suicide, that they will step forward. Madam Speaker, I'll just close in this. I have a few minutes left. We have an incredible Canadian Armed Forces. The one thing that we recommended through the Defense Policy Review a few years ago, and which is reflected in the Liberal defense policy now, is that the number one source of pride within the Canadian Armed Forces are the personnel, and that we want to ensure that we give them the tools to do their job. Whether they serve in the Canadian Army, the Royal Canadian Navy, or the Royal Canadian Air Force, these brave men and women do incredible work to keep us safe here at home. They stand on guard 24/7. When you walk into NORAD, whether it's down in Colorado Springs or their Canadian operations in Winnipeg, they have right on the wall, we have the watch. And they're on the watch 24/7. We often forget that there are all sorts of threats coming at us, whether it's airborne, seaborne, or even potentially on the ground. And because we have troops deployed across this country and around the world, we are safer here at home. Because they are standing on the wall, often in places like Latvia, today in Mali, and Ukraine, along with many other locations, they are ensuring that we can continue on with our business, oblivious to what's going on in the world and potential threats such as cyber hacking, knocking down our financial systems, our energy sector, blocking off our naval routes to ship our goods back and forth over the sea. Our economy, our safety, our prosperity is built upon us as Canadians, but more importantly, it's defended by those that serve in the Canadian Armed Forces. And on behalf of all Conservative members, indeed members of this House, I'd say thank you for you that serve, because you keep us the true north, strong and free. Yeah.
Questions and comments? Questions et commentaires? The Honourable Member for London Fanshawe.
Well, thank you very much, Madam Speaker. I heard the members say very clearly that we need to restore the rights of victims. And I did listen very carefully and would ask, given the reality of PTSD and mental health issues among Canadian military personnel, and the failure of this government to strike Section 98C that makes self-harm a disciplinary offense that could mean life imprisonment for a victim of PTSD who attempts suicide, will the member continue to support NDP efforts to remove Section 98C, and will he support our private member's bill C-426 that seeks to finally do the right thing and remove Section 98C?
The honourable member for Selkirk-Interlake Eastman.
Well, Madam Speaker, as I said through my speech, that I appreciate the hard work that the NDP defence critic, the member from Esquimalt, Saanich-Sooke, has done on this. I have talked to Sheila Fines as to other family members who also, and other members of the Canadian Armed Forces who believe that 98C need to be removed. Now, I know that there's some concern making sure that we balance off those that intentionally harm themselves to stay out of service, whether it's on exercise or going into theater, those that literally shoot themselves in the foot, versus those that are stigmatized because they need the help because of their mental health issues through PTSD and other operational stress injuries. So, as I said, I would look at this private member's bill. I will work alongside any member in this House on how we can strengthen the military justice system while we destigmatize those that are dealing with this problem of self-harm. And Madam Speaker, I think that really it comes down to is that we should work quickly and maybe even task the Standing Committee on National Defence on how do we balance off the concern of making sure that those that are held to account that are trying to avoid service versus those that are trying to hurt themselves and will commit suicide because they are dealing with operational stress injuries. So I'm here to work with anyone that wants to carry that forward. Thank you, Madam Speaker.
Questions and comments? The honourable member for Guelph.
The honourable member across the way. The proof is in budgets, and the proof is in investing dollars in the sports that are needed. The previous government was cutting services and cutting Veterans Affairs offices and cutting mental health support. So would the member across the way agree that investing in mental health, such as our new mental health centers of excellence that we've opened up, and the restoring of the support offices is a good way to head, and that we need to put budget money forward to support our veterans and our military personnel?
For Selkirk-Interlake Eastman.
Well, Madam Speaker, I just draw the members to the PBO report this week, which showed that the Liberals failed and broke their promise on bringing back pensions for life. They missed it by about $20 billion. They're only spending about, they're close, yeah. It was but not even close. And that those that are the most injured as veterans will receive $300,000 less under the Liberals. The people that need the most help are getting less. So, Madam Speaker, that is not a record that that member should be standing up and bragging about. Veterans across this country are incredibly upset with the broken promises that they had from the Prime Minister and from this government. And, Madam Speaker, it does really reflect that all we saw was electioneering. We didn't see any compassion when it actually came for services to our veterans.
Questions and comments? The honourable member for Central Okanagan, Similkameen Nicola.
Thank you, Madam Speaker. When I sat on the Finance Committee, and I'm actually going to bounce off of what the member for Guelph just asked. When I was on the Finance Committee, we actually saw changes for the Pensions for Life program come through the omnibus bill. It went to the Finance Committee. We had very limited witnesses to be able to ask about this, and there was questions with the proposal for Pensions for Life, where a female service member would receive substantially different than a male based on how long they would live, Madam Speaker. And so I'm very concerned that this government is treating people differently. Are there any concerns by this member in this piece of legislation that would treat members differently within our armed forces when they're facing the justice system?
The honourable member for Selkirk Interlake Eastman.
I want to thank my colleague from Kelowna for his input and for his hard work that he's been doing on the Finance Committee and standing up for veterans, something that we have always done and will continue to do. This legislation, I think, balances off the rights of the victim along with the rights of those that have been accused of conducting criminal activity or violating the Code of Service Conduct or violating the Queen's regulations and orders, that they will have the chance to appeal some of these decisions, that they will always be treated fairly and with respect by the chain of command and by the Judge Advocate General. Some of the concerns that I raised on making sure that the burden of proof is dealt with through regulation has to be taken in consideration because that was raised by expert witnesses on the legal system, and ensuring that those things are put in place to protect those that are accused, as well as we already have now the rights of the victims embedded into the National Defence Act.
Then comments. The honourable member for Port Moody, Coquitlam.
Thank you, Madam Speaker. I appreciate the comments from the member from Selkirk Interlake Eastman, but my colleague from London Fanshawe asked earlier about under C-77, it's still actually seen as an offence under military justice to commit self-harm, and I appreciate the member's comments, but the direct question is, would he support and would his party support the striking of this to make it, to remove it as an offense? So I want to give the member another opportunity, a chance to answer that question. He did talk about the great work of our defense critic, but didn't really answer the question. So I'd like to provide another opportunity to say, will he support this move to strike this? Thank you, Madam Speaker.
The honourable member for Selkirk Interlake Eastman.
I want to thank my friend for that question. And yeah, to be very clear, 98C should be eliminated. For those that have concern that we need to make sure that those that malign themselves or malign others to avoid service, not necessarily out there to self-harm, but they will harm themselves to stop from being deployed, as an example, that needs to be dealt with in another part of the legislation. Maybe it's strengthening 98A and B. So it might be a two-tiered system, but 98C, which is part of the problem with self-harm and the stigmatization that we see around mental health and suicide within the Canadian Armed Forces, needs to be eliminated. We had that chance to delete that clause and unfortunately was ruled out of order.
Comments. The honourable parliamentary secretary to the Minister of Families, Children and Social Development.
Thank you very much. One of the components of this piece of legislation deals with hate crimes, or a variation of hate crimes. We know in Toronto we had a very high-profile case where reservists assaulted a homeless man, in fact murdered a homeless man after coming off of duty at a local armory. The armed forces are drawn from all corners of the country, and they're no better or worse than any other group of people. And I'm not meaning to suggest that there's a systemic problem in the armed forces, but I didn't hear the member opposite address the issues of what happens when homophobia, what happens when LGBTQ two-spirited individuals are either within the armed forces or even in proximity to the armed forces, when their rights are not respected properly by members of the armed forces. There are penalties and provisions to hold people accountable and to protect those communities. Does the member opposite agree with those provisions and support those?
The honourable member for Selkirk Interlake Eastman, a brief answer, please. No,
Madam Speaker, the member didn't listen very closely to my speech then, because I actually talked about in the speech that this changes within Bill C-77 increase the standards under the Code of Service Conduct. So Operation Honor will be more able to stomp out sexual misconduct, stomp out intolerance, whether it's racism, whether it's homophobia, whether it's violations against those based upon their sexual orientation, and it will also stomp out harassment. So the Bill C-77 works all of that into the National Defence Act, provides greater power to the military justice system to take action on that, and supports those in the chain of command as they execute Operation Honor. Thank you, Madam Speaker.
Resuming debate, and I just want to remind the member that unfortunately I will have to interrupt him, and he'll be able to continue his speech after questions and question period. The honourable member for Courtenay Albany.